Thank you, Dr. Morris. You don't get to do all that stuff that I've done unless you're an old man. And thank you, ladies and gentlemen, for having me here today. I was sitting down there a while ago thinking, had a little flashback, and it feels like that my life has sort of come full circle being here with you today. It was 45 years ago next month that I got out of law school down at Baylor, and I came up to Dallas and went to work in a pretty good-sized law firm here, and it was right down on North Central. And very early on, I got assigned a case to represent an insurance company that underwrites bail bonds, whose agents sold bail bonds here in Dallas County. And little did I know, and in fact, I didn't want the case. I felt like I was being slighted, and I only got it because I was the new kid in the firm. But little did I know that that would set the stage for the next 45 years of my practice. So it's especially nice to be back here in Dallas today. And again, thank you for having me. I asked Dr. Morris, I said, what should I talk about? And he said, this is not a bail bond knowledgeable audience in all likelihood. He said, why don't you just tell them a little bit about what the commercial bail bond business is really like, what it's about, what it is, and then what its place is in the nation's criminal justice system. So, I think those are good objectives because, first of all, most people today, while they know what a bail bond is and they know what a bail bondsman is, they don't really necessarily have a good understanding of what the industry is and does. And since they have less than a complete understanding about that, I don't think they fully appreciate actually the indispensability of that industry in our criminal justice system today. So what I'd like to do is those two things. I'd like to talk to you a little bit about what commercial bail bonding really is, and then I'd like to talk to you about the role that it plays in our criminal justice system. Probably the best place to start in describing what commercial bail bonding really is by telling you a little bit about what it's not. For example, it's not what the Hollywood screenwriter says it is. It's not what the current crime novelist says it is. It's not even what today's reality television shows depict it as being. They find it necessary to sensationalize the industry. It sells more copy for them if they can paint the bail bondsman as being a sort of a murky character, questionable in his ethics, really just like the guy he's getting out of jail except for which side of the bars they happen to be on. Nothing could be farther from the truth. Bail bonding is nothing more or less than a type of insurance sold in America today. It's a type of insurance known as surety business. The agents who sell this insurance product are every bit as qualified, credentialed, schooled, continuing education requirements. They have to jump through all the same kind of hoops that every other licensed insurance agent in the country has to jump through in order to be in the business that they're in. To try and describe exactly how the bail bond business works, let's take an example. Let's say that the Board of Regents here at the University of Texas in Dallas decided that it wanted to build a new performing arts center. Of course, Dr. Morris walked me by the one you have, so you don't need one, but let's pretend that they want to build a new performing arts center here on the campus. Well, they're going to go to a big architectural firm, and the architects are going to draw up the plans and specifications, and then they're going to give those plans and specifications to an attorney, and the attorney is going to draw up a contract. And this contract would be the one that exists between the general contractor who's going to build the building and the University of Texas at Dallas. And let's further pretend that as this discussion between these two parties begins to develop, the University of Texas Board of Regents says, well, you know what? We're a little bit concerned that despite your good track record and history in building buildings in Dallas County, we're a little bit concerned that something might happen and you might not be able to finish this work. And then we're going to be left in the lurch because we would have spent a lot of money getting it built up to the point that it is, but then it doesn't get finished unless we go out and hire somebody else. So we would like some protection on that. We would like for you to go get some big financial institution like a big insurance company that guarantees the performance of general contractors like yourself to build big buildings like this. So that we would know that if something happened to you and you couldn't perform, they would take their money and step into your shoes and see that the job got done. We want your promises of performance secured financially. So this contractor is not surprised because he always has to go get a performance bond. And so he goes to the insurance agent that he normally buys these bonds from, and he gives him the contract for the construction of the new Performing Arts Center. And that agent runs it through the underwriting department at the insurance company, and they agree to underwrite the risk. And so they write a bond that simply says, it simply says to the University of Texas at Dallas, if this contractor does not finish this job exactly pursuant to the plans and specifications that are attached to the contract, we will step in and finish that job for him and for you. We will guarantee his performance. We will see to it, in other words, that his promises to you are ultimately going to be kept. And if he doesn't keep them, we're going to keep them. And so they closed the deal based upon the bond. Lots and lots of surety bonds written in this country, thousands every day, ladies and gentlemen. They are an integral part of commerce. As a matter of fact, the American Bar Association, just last May, published this book. It's called The Law of Commercial Surety and Miscellaneous Bonds. And it describes 20 different kinds of surety bonds that insurance companies underwrite in this country, and it gives you the law surrounding each of those types of undertakings. Chapter 8 is about commercial bail bonds. It's just one of the 20 types of bonds described in this volume. That chapter 8, incidentally, you can go to the website that's, you get the address on this data sheet over here, and you can pull that article up and read it for yourself. And it'll go into a lot more detail about this subject than I'll have time to do today. So, all of these 20 types of bonds, surety undertakings, have the same thing in common. Every one of them guarantees the promises of a contractor to another party. Okay? Now, that's all a bail bond does. How does the bail surety work? Well, let's say that a man named John Jones is picked up by arresting officers. They, in good faith, believe that he committed a criminal offense, and it can be any one of 1,000 things. But let's say that this one is sort of serious. Let's say that it's breaking and entering a private residence by nighttime. It's a burglary bond, a burglary offense. And so they take him down to the jail and they book him in on that offense. And the next day he goes up before the magistrate, and the magistrate wants to know, do you have a lawyer? The magistrate wants to know certain things about him to protect his rights. And then the magistrate knows that this fellow has been in trouble before. And he knows that he doesn't have very strong community ties. And he also knows that, this guy probably knows that if he's convicted of this crime, he's going to do about 5 years in the state penitentiary down in Huntsville. And so he figures that this man may be something of a flight risk. He may not want to come back for trial. And so he says, I'm going to set as a condition of your pretrial release, as a condition for you to be able to get out of custody before your trial, I'm going to set your bail at $10,000. And I want it secured. Well, Mr. Jones gets back to the cell, he makes his phone call, he calls his girlfriend or his brother or whomever he feels he can rely upon best. And he says, listen, they've set a $10,000 bond on me, go get a bail bondsman to write the bond. So that person who wants John out of jail goes to the Yellow Pages or he goes to the internet and he finds local bail bondsmen. And he selects one of them and he goes down and he makes arrangements with that local bail bondsman to go get John out of jail. Now, in order for John to get out of jail, John's going to have to make a couple of agreements with the court. He's going to have to sign a bail contract. And in that bail contract, he makes two promises. He says, Judge, if you'll let me out before my trial, I'll come back when I'm supposed to, and Judge, if I don't, I'll pay the $10,000. And the judge says, well, John, no offense, but I don't have a lot of confidence in you keeping your promises. So I want your bond secured. I want somebody to guarantee the court that they'll get you to court, and that if they don't get you to court, they'll pay the $10,000, and there's got to be somebody that's stand up financially that knows how to do this thing. In other words, an insurance company that underwrites bail bonds, not the construction bond, but a bail bond. Now, what is that insurance company doing? It's guaranteeing that John's two promises are going to be kept, and if he doesn't keep them, they're going to keep them for him. They then say to the court, Judge, let him out, and we'll get him back when you want him back. And if we don't get him back when you want him back, we'll pay the $10,000 unless within the specified allowable period of time, we go get him and bring him back and surrender him back into custody. Now, folks, that's what a bail bond is. It's an insurance company guaranteeing the court that John's two promises, I'll come back or I'll pay, are going to be kept. That's simply called secured release. Where'd that come from? I mean, how far back in our country have we had that practice of securing someone's release so they can get out of pretrial custody? Well, we've had it longer than our country. I got curious about that a number of years ago, and I did a little research on it. And I was able to find one of these secured releases in a criminal proceeding as far back as ancient Egypt when the pharaohs were ruling that land. There was actually a case where some guys were accused of being spies. And they said, if you'll let us go back to our home, our country, we can get you proof that we're not spies. The court official, as it were, said, I'm going to let you do that, but you're going to have to put up some security to guarantee that you're going to come back. And they did. And they went to their land and they got the proof and they came back and offered it to that court, and the court set them free and gave them back their security. Now, move forward 1,000 years or so to the days of King Solomon. I actually found some references to secured release in the wisdom of Solomon's Proverbs. There's one that I like in particular. Here's what it says. He who goeth surety for a stranger shall surely smart. In other words, you don't want to guarantee the performance of a pure stranger because he's going to be gone and you're going to have to pay the money. Now, every bail bondsman today, and there's one sitting right here in the audience with an enormous amount of experience, and he'd be very leery about writing a bail bond to guarantee the court appearance of a pure stranger. Well, Solomon died in 931 BC, so that's about 3,000 or so years ago. Let's fast forward across some centuries to the Statute of Westminster in England, when the British Parliament was debating that statute, and that was in 1275 AD, and they were talking about bail then. Now, another 400 years later, also the British Parliament, they had a problem. The judges in England in those days were setting bails so high that nobody could ever possibly make them. And these members of Parliament were concerned. They were voicing their being bothered by this proposition that if you set bail so impossibly high that nobody can ever make it, well, that's tantamount to no bail at all. And they were right. And so they wanted to fix that. And so they crafted some language, and they put this language in the English Bill of Rights. And what the language said very simply is, quote, "There shall be no excessive bail." 100 years or so later, when the American colonies began to be founded, the colony of Virginia wanted to codify its criminal procedure. And it got down to the subject of bail, and they said, what should we do about this? How can we make it fair? And they reached over into the English Bill of Rights and they plucked out those very words. And they put it in the Virginia Colony Bill of Rights. There shall be no excessive bail. Framers of the Constitution were trying to hammer out that document and get agreement on it. And there was a lot of bickering about one thing. And some of these gentlemen were saying, well, you know what, we've made all these provisions in here to protect the federal government, the new federal government, and we've made these other provisions to protect the states. But we don't have any provisions in here to protect the rights of individuals. What about individuals' rights? And so they began to write up a list of things that they needed to have in the Constitution, in their opinion, to protect the rights of individual citizens. And they wrote up about 12 of them. They picked the top 10, so to speak. And they called that the American Bill of Rights. And they put that out for ratification by the states, the new states. And it required a vote of approval of 75%, 3/4 of them. And I think that magic number would have been about 10 in those at that time. And they put that out there in about 1884, something like that, 84, I believe it was. And the states began the ratification process, and they had their conferences, and they talked, and they voted, and they got, I think they had to have 10, and they got down to 9, and they needed the 10th one. And finally, the holdout, Virginia, said, okay, we'll do it. We'll do it. And that was in 1791. And so that became the American Bill of Rights, those amendments to the United States Constitution. And guess what the 8th Amendment